in right here. At the end of that one.
So you're telling me that you've added on to the docket?
We added on this docket, we had a late file.
And then you,
We are,
I think we have a special needs lawyer, so we're going to go ahead and take him up first. Mr. Runyon, what do you have?
Thank you, Judge, very much. Page 2 of the docket, David Allen Freed, CR 48, Mr. Freed. If somebody please fast forward a plea petition and TBI certificate of eligibility.
Your Honor, can we just hold this one moment? We have a family member who's going to make a brief impact.
Okay.
I probably won't be in here for that.
All right. So is this a victim impact statement that you're going to?
They're here. They're here.
Is it a victim impact statement?
Yeah, it's a vehicular homicide, Your Honor, that we have negotiated with the family's blessing. And they would just like to make a brief statement.
All right.
They are in full support of this settlement.
All right.
Okay. Right here.
All right. I've been handed a document indicating that Mr. Freed is going to be entering a plea to an amended count 1, which is an amended charge of criminally negligent homicide, a Class E felony. And pursuant to 40-35-313, he would be placed on 1 year's probation, and he would be required to attend the victim impact panel. And that all the other charges would be dismissed. Is that correct? All right. Mr. Freed, raise your right hand. Let's place you under oath.
do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Would you, is this a guilty plea or a nolo contendere?
Guilty plea, Judge.
State your full name for the record.
David Allen Freed.
Mr. Freed, you are here today on a 3-count indictment. You heard me go over what the agreement is that your lawyer has worked out with the state with the consent and agreement of the victim's family in this case. But have you seen or been shown a copy of those charges, talk them over with Mr. Runyon? You and he discussed the range of punishment you're facing as well as any possible defenses you might have. Well, as indicated, move that microphone up so that, yeah, it'll be, there you go. You don't have to bend over, but it picks up better since we're recording. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court? You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own. You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you can be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you and Mr. Runyon could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena.
Yes, Your Honor.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. And all I'm going to do is approve what your lawyer has worked out with the state and with the consent of the family.
Yes, Your Honor.
You understand that under 40-35-313, you're going to be placed on probation for 1 year. If you successfully complete the terms of that probation, then after that year's probation is expired, you would have the right to come in and have your record expunged or wiped clean as though this had not happened. You understand that?
Yes.
You understand likewise that if you violate the terms of that probation, get convicted of some or get arrested for some new offense, or you violate the terms of the probation for any reason, then not only would this become a permanent conviction and be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime, but it would also mean that you could be brought back before the court and you could be re-sentenced to a greater amount of time in prison within the range of punishment that applies for that case. Do you understand all of that?
Yes, Your Honor.
Do you understand everything I've explained to you thus far?
Yes, Your
Do
Honor.
you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
I do, yes, Your Honor.
You understand that if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you are lying under oath.
Yes, Your Honor.
Is your decision to plead guilty today voluntary? Is anybody forcing you to do this against your will?
No, sir.
You understand, I cannot accept your plea unless I'm satisfied that there is a factual basis for it and that you are in fact guilty.
Yes, sir.
Well, and that even though this is a guilty plea, are you going to give me a factual basis for it, General?
I can, Your Honor. Your Honor, if this had gone to trial, the state would have put on proof that on August 29th of 2024, the defendant was driving with his friend Braxton James Madden here in Stewart County. They were driving a Miata. He misnegotiated a curve and the vehicle flipped, ejecting Mr. Madden. The reason for the plea, Your Honor, is at the time it was not initially investigated as a homicide. His blood did come back with some THC in it, but in talking to the experts, their testimony would have been that it hadn't reached his system yet. And there was no way to determine the speed of the vehicle because it was so old, the box. But based on some of the defendant's statements that he was going too fast for the curve, and with the family's blessing on it, that is the reason that we have come up with this.
All right, Mr. Freed, do you understand that's what the state's evidence would be if this case went to trial?
Yes, Your Honor.
You still should plead guilty according to this agreement.
Yes, Your Honor.
Are you satisfied with your attorney services?
Yes, sir.
Feel like Mr. Runyon has done a good job of representing you competently.
I do, Your Honor.
Mr. Runyon, you know of any reason you should not enter this plea?
I do not, Judge.
All right, if you will then have a seat here to the right, it's my understanding that the victim's family has a statement they want to make.
Well, just like to apologize to the court for my attire.
All right,
I wasn't aware of the short policy, but David, I want you to know, man, we don't hate you. Understand? So my son. And we drove him like we stole him and rode him till the wheels fell off, but me and my son always did that. We had this conversation, so I have on many occasions. Fortunately, I have one of my friends. Just hope you take this and realize that I don't think anybody else would be as compassionate as we are. But what I've talked to about is that we'll go to prison, take prison. We don't see any more choice in destroying any more lives in this whole ordeal, so carry this in your own self, it's your own prison. No, you are. Just want you to know that we're not mad. Trying to do the best thing of what our son would want. It's pretty much. Wouldn't want you to go to jail. I don't want you to go to jail. I know what jail does. And they're a lot. Get better criminals. Well, we left Arizona. But I just want you to know that we're not mad at you. What it is, but you guys went out of party drinking or it wasn't nothing like that. A young man going to go out and check out a restaurant. Hope you take the second chance at life, but you know, try to stop one other person from doing it. That would have some life with loss. Let me know. Sorry.
Thanks. Wish I had that on video. Okay.
I don't see this very often in court where the victim's family in a case like this is so forgiving and compassionate that they are willing to not only agree to a disposition that a lot of people wouldn't agree to, but also have forgiven Mr. Freed for the taking of the life of their loved one. This is an opportunity for you, Mr. Freed, to basically have a clean slate after you've finished your probation. And you need to thank the Madden family because they're the ones who are giving you that opportunity. It would not happen without their consent. And obviously you have a close relationship with them. And I'm sorry that the circumstances are such that you have to be here today and that they have to be here today. But upon your plea of guilty to the charge of a criminally negligent homicide and amended count 1, counts 2 and 3 are dismissed. You're ordered to be sentenced, placed on probation for 1 year with the Department of Corrections under 4035-313. It's a requirement of your probation. You must attend the victim impact panel. You'll need to pay the court costs as well. So, is that correct? Thank you. You need to see probation before we leave.
Thank you.
All right.
Judge, on page 8 of the docket, Michael Varner. You are 38. If I pass forward, he is currently in safe harbor. He's there today as we speak, or supposed to be anyway, at recently last week when I got an updated report. It's my understanding it's either a 9-month or a year-long program. He entered in December. If we set this for maybe August for a review.
All right. You want to set it in August, late in August? I can find it quickly. So it would be August the 10th.
August 10th. Thank you so much, Judge. Thanks for calling me. Thank you.
All right. We have a matter of statements with Paul Davidson that we need to deal with. Is that correct? Cases.
Go ahead.
Go ahead. No, I'm just saying the case is set for trial, and I'm understanding you have a motion to continue.
I do, Your Honor. This, and Miss Santiago, the victim's guardian, it's a minor child victim. She should be in the Zoom waiting room. We're about to be there. This family lives in Florida, and I thought that we were going to be able to have them come up without having to do the interstate subpoenas through the governor's office, Your Honor, but it does not appear that's the case. I just want to put on the record what her struggles in getting off work are and actually attending in person. I've explained to her that this is not a case that we can do via Zoom, Your Honor. And defense is not agreeable to it anyway. I understand the defendant's in jail. The state is agreeable for an OR bond at this point, as long as we can keep the case going. Or some other appropriate bond. I don't think he's a flight risk, but I do want Ms. Santiago to state to the court and explain what her issues are in getting to Tennessee.
Ms. Santiago, are you able to hear everything?
Yes, sir.
All right. Need you to raise your right hand and let's place you under oath.
Okay.
You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, thank you. Ms. Allen, our district attorney here, has some questions that she wants to have you state something on the record, and then we'll take care of.
Okay.
You are Melissa Santiago, is that correct?
Yes, that's correct.
The record, please. Can you spell your last name for the record?
Yes, Santiago.
And where do you live?
I live in Palm Bay, Florida.
Okay. And does the victim in this case, Brian Ward Jr., does he live with you?
Yes, he does.
And what is your, if any, familial relationship with him?
He is my nephew, paternal nephew, my brother, my brother's son.
And are you now his guardian?
Technically, no, he's still the guardian of Tennessee.
Okay. Do you have any formal custodial relationship over him through the courts?
Yes, I do.
Okay. All right. That's what we needed to know. And is his father, Brian Ward Sr., is that your brother?
It is. He is.
Now, are you employed, Ms. Santiago?
Yes, I am.
Okay. Where do you work?
I work at Instructure in Port Canaveral, Florida.
Okay. Are you remotely employed or do you go into the office every day?
No, I'm in the office every day.
Okay. And do you also have children of your own?
I do. I have 3 children of my own.
Okay. And are each of those children minor children?
Yes, my daughter is 13 and my twins are 7.
And do you have full custody of them?
I do, 100%.
Does anyone else, is there a father, stepfather, or any other figure that gets them on weekends or holidays or anything?
No, they haven't seen their father in a year.
Explain to the court, if you could, what the issue is with you taking off work and coming to Tennessee.
I don't have any childcare. My family lives out of state. They're all up north, up in New Jersey, and we're down here alone. So I don't have any childcare besides school and after school programs.
Are you allotted a certain number of days where you can take off from work a year?
Yes, ma'am.
Okay, and how many is that?
I receive 10 a year and I've already used 7.
Okay, and 7 of those, what did you use those 7 days for?
Some sick time when we had the flu and other illnesses, and there was also a vacation taken that we had planned over a year ago.
A vacation? Okay, so you
Yes,
have
ma'am.
that you could use for this trial if needed and not be penalized for work, is that correct?
I do, but I've already reserved plane tickets again for Thanksgiving in November, which are reserved way in advance.
If you were issued a subpoena through your state's office, would you honor that subpoena and come and bring Brian to court?
I wouldn't be able to receive to obtain childcare.
If Zoom testimony was allowed, is that something that you think you would be able to do?
Me? Yes, of course I would.
But you understand that a subpoena is going to be a court order. If it's served on you, it will need to be followed.
I absolutely understand that, but I still can't obtain childcare.
And you
Or the
understand,
means, or the financial means to bring my children with me to Tennessee to court.
do you understand that the state would pay for your and Brian's travel and accommodations?
For Brian's and mine, but what about my other 3 children?
Not speak to that. That's all the questions.
Okay.
All right, I think, Mr. Clemens, I'm not sure there's any basis in you questioning this with us, but, all right. Thank you, ma'am. Ms. Santiago, we're going to release you from this hearing and I'll deal with the other issues. Thank you.
Okay, sir. Thank you, Your Honor. Bye-bye.
All right. We have a motion to continue the trial that's set for tomorrow. And obviously you've got the problem is that this child is living with a relative out of state and therefore going to require a cooperation of both the governor's office in issuing this subpoena. But how long has this case been pending?
Since last September.
September, Your Honor.
And we have a motion for a bond set by Mr. Clemens.
And the
I'm
state,
inclined, if I'm going to grant this continuance, that I will grant an OR bond to the defendant.
Yes.
And that way he is able to be released pending the trial, if in fact the trial can occur. Because obviously if your victim's not going to appear, then Mr. Clemens is going to be moving to dismiss down the road.
this is, the state fully expected that, Your Honor. And it's a very frustrating position to be in, but we are going to go forward with the interstate subpoenas and trying to.
Mr. Clemens, let me hear from you. If I grant this motion, continue, but grant your client an OR bond, I know you have some other motions. I think if you.
Yes, Your Honor, that would be perfectly agreeable. I discussed that with my client, that if the state was agreeable, if he was OR today to reset, I got some motions filed that says reset everything at the court's convenience.
Well, my thinking is that it's not your client's fault that the case is going to have to be continued, but neither is it the fault of the district attorney's office. It's apparently the issue with the custodian of the child in Florida that's creating the problem. And it may not be able to be resolved down the road, but right now what I'm going to do is grant the motion to continue, grant your client an OR bond with the condition that he stay in touch with you as a condition of his bond.
Yes, Your Honor.
And that you have regular contact with him so that we can make sure where he is.
Yes, Your Honor.
Where does he live?
I could ask him, Your Honor. I don't know off the top of my head. I know this is Mr. Davis here. He lived here in Stewart County. Is that correct? In Henry County. Sorry, Your Honor. He lives in Henry County.
Well, I think we just need to put as a condition of his bond, he would maintain his residence in Henry County, but I don't want him leaving the area.
Yes, Your Honor.
Obviously, an OR bond condition upon him maintaining his residence in Henry County.
And Your Honor, the state will respond to the motion for bill of particulars, and we'll probably be able to work out the motion.
All right, then what I would do is just reset this for the, I guess, since he's gonna be on all our bond, let's put it on the 13th of, I'm sorry, the August date when I'm next here to set a trial date on that day, or do you want to go ahead and assign a trial date?
Go ahead and sign a trial date, Your Honor, because we are going to start working on these subpoenas and
You've got the 12th, I'm sorry, the 11th, 12th, and 13th.
It's fine. Any of that's fine.
can we do the 11th and then maybe reserve the 12th? I don't think it's going to be a long.
All right, we will put it on the 11th. It'll be the first case to be tried.
Thank you so much.
So for the clerk's information, I've granted the OR bond to Mr. Davidson. So his condition of his bond is they maintain contact with his lawyer and that he maintain his residence in Henry County. All right. This trial is set for August the 11th. Mr. Flanagan, I see you on a screen here. Can you tell me what you have today?
Judge, I've got Nina Norfleet. She is in the courtroom.
Ms. Norfleet, this is here for status.
And Judge, for a number of reasons, this is not ready to be set for trial yet, so I need another status date.
All right, that would be August the 10th.
Yes, sir.
That would be the last status day. That means that if the case is not resolved on that day, then we will have to set it for trial.
Yes, sir.
Thank you.
Thank you.
You have anything else here?
I hope not. If I do, I hope somebody will take care of it for me.
I'm sure there will.
Thank you, Judge.
All right. Let's then move to the regular call of the docket. Let's see who we have in inmates here. Dalton Bromley.
Current violation of probation, we have post settlement on that.
Yeah.
Judge, if I may please pass up this post order. The effective, which would be revoked to serve 90 days with credit for his time since he was arrested on these violations in March. And then reinstated after the service of the 90 days. He may also apply for rehab if he would like to do so.
Mr. Bromley, raise your right hand. Let's place you under oath.
Do you solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your full name for the record.
Dalton Lee Bromley.
Bromley, you've heard your lawyer go over what the agreement is. Do you understand that you're here on a violation of probation, that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation?
Yes, Your Honor.
You understand that if we had that hearing, you'd have the right to have a lawyer and have one appointed if necessary, which we've done with a public defender. You understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to that hearing without appeal. All I'm going to do is approve what your lawyer has worked out with the state. And that's going to require you to serve 90 days with credit for time served and then reinstate you to probation with the condition that if you want to apply for a rehabilitation program, then that will be authorized as well. You understand everything I've explained to you?
Yes.
Do you want to plead guilty according to this agreement?
Yes, Your
And upon your plea of guilty, I find you guilty, or that you be revoked the servant sentence, but to serve, 90 days with credit for time served, and thereafter you'll be reinstated to probation with a condition that if you seek to apply to, I'm assuming that application to a rehab would be while he's serving that 90 days. So then you'll be authorized to have a furlough if you're accepted into inpatient treatment, so. Okay, all right, thank you. All right, go, Mr. Davis. You want to call the next inmate?
Peter Pagulchagrat, I think. I try to pronounce it that way, but he's not a.
Peter Pagulchagrat, Thomas, is this yours?
Don't believe he's up here yet, Your Honor.
Okay.
Robert Kaiser, he appears to be here.
Robert Kaiser.
Judge.
Hey, Thomas,
Yes.
real quick.
Your Honor,
Yes, sir.
there's a few motions on the docket, state's ready, whatever you are, I know. But I think we're gonna have to discuss this case in chambers before we move forward.
All right.
Yes, Your Honor, I'm ready for the motion to suppress. I just wanted to discuss a couple other motions in chambers before we move forward.
All right, well, let's pass it and we'll come back to it after we've gone through the docket. We're ready for hearings. All right, thank you. Excuse me. Hey, Mark Wells, F. Seabury.
It's Your Honor. Take on this, Your Honor, only request is a speedy trial, please. There, Your Honor, that's it.
Speedy trial
Set for trial today.
tomorrow.
We have a trial yet?
Not yet, we're just setting our status today.
Maybe the 13th, so we don't run into holiday.
Well, we have the 12th and the 13th. You want to put it on the 12th or the 13th?
I'd like to do the 13th, just in case Paul Davidson goes. This will be a one-day trial. It will not go 2 days.
All right, Mr. Seabury is set for trial on the 13th of August.
Thank you, Judge.
Thank you. This is, I guess that was our last inmate other than Mr. Kaiser, so let's go to the regular dockets. Twenty 62 State versus Justin Lee Bernier. Clemens,
Yes, Judge. He's here. Got a hurt leg, so it's gonna be a little slow coming up.
let's start.
I believe Your Honor will simply need to, if Your Honor will allow, reset this for Judge Wallace's court date coming up. I've been informed they're anticipating an amended violation of probation warrant that we might consider on later.
Will, Judge Wallace's next day is May the 11th. We'll reset it for that day.
May 11th. Thank you.
Right on page 3 of the docket, 2025-065 State versus Richard Gordon Stevens. Good morning.
Great this morning.
Hi.
Otherwise, we'll accident.
Got a long way to come from Cheatham County.
Yes, sir, just a little bit.
Your Honor, we're asking for one more status date for this case. I think we'll settle it. There's just a few details that we're working out between our client and victims. And I'm pretty confident this was.
I would, if it's on my docket, it would be that August the 10th date,
August 10th.
August 10th.
Thank you, Judge. Thank you.
That all you had, Ms. Stevens?
Say again, Judge?
Is that all you have?
Yes, Your Honor. Thank you.
And safe going home.
Yes, Judge.
Looks like 2026 CR7, State versus Jennifer Holloman. Mr. Clemens for status. May have stepped out. We'll put it on this. Just let your lawyer come up. So. Sorry, Mr. Clemens, this is Jennifer Holloman.
Yes, Judge, we have a settlement ready on this one. Pass this up, please.
All right, thank you.
Pleading guilty to the charge, amended to attempted forgery, received a sentence of 11 months, 29 days suspended and a $50 fine.
Holloman, raise your right hand. Let's place you on the road.
You solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your full name for the record.
Jennifer.
Ms. Holloman, you are here today on a charge of forgery. It's been indicated you're going to plead to an amended charge of attempted forgery. But have you seen or been shown a copy of the charges against you? Talk them over with with your lawyer and Mr. Clemens, and you discuss the range of punishment you're facing as well as any possible defenses you might have.
Yes.
You feel like you fully understand what you're charged. You understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court. You understand that by pleading no contest or no contendere, all that means is you're not going to admit you did anything, but you're not going to contest the state's evidence when they tell me what their evidence will be, and that evidence will be used by me to find you guilty according to this agreement. You understand all that? All right. You understand that you would have, if you went to a trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender. You understand that if you went to trial, you'd be presumed to be innocent until such time as ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything. You understand that trial, you and Mr. Clemens could confront and cross-examine every witness the state called to testify, and you can bring in your own witnesses by using a subpoena. You understand that if at trial you'd be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading no contest, you're waiving your right to that trial and to the appeal. All I'm going to do is approve what your lawyers worked out.
Yes.
You understand that that is going to result in a misdemeanor conviction, and that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand everything I've explained to you?
Yes.
You want to plead no contest according to this agreement and waive your right to a trial and to an appeal. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty. And listen, as the state tells me what their evidence will be if this case is going to trial.
Your Honor, the state would put on proof that if this case had gone to trial on May 14th of 2025 and July 23rd of 2025, she was on probation with Ms. Donnelly here. She had volunteered to do some community service, so she had a community service timesheet that she was supposed to present to the court. She did a couple of days of that, and then she signed the supervisor's name to the rest of it. The state has talked to her attorney, and we are going to give Ms. Holloman one more chance to get out there and do probation. She'll either get it or she won't.
Right. Ms. Holloman, you understand that's what the state's evidence would be if this case went to trial.
Yes.
You still wish to plead no contest according to this agreement. Are you satisfied with your attorney's services?
Yes.
Feel like Mr. Clemens has done a good job of representing you competently.
Yes.
Do you know of any reason she should not enter this plea?
No, Your Honor.
Ms. Holloman, this is the last chance that you're going to have to avoid going to jail, so make sure you make the best of it. On your plea of no contest to count to the attempted charge of, to the amended charge of attempted forgery, a Class A misdemeanor, I find you guilty. Sentence you to 11 months, 29 days in county jail, but that will be suspended to supervised probation in order to pay a $50 fine and court costs. Good luck to you. Do we have another inmate?
Not yet.
Who's this individual?
And you've already talked to
Oh,
him.
okay. Yes, sir. All right, just let me know when we go see those. 2020 CR 104, State versus Melissa M. Holloway, Mr. Clemens. Actually, this is the petition of Freebird Bonding Company to be exonerated. I'm gonna have to review that file before I can make any sort of determination on it, so we'll pass it to the end of the docket so I can get it over.
Yes, sir, Your Honor.
Oh.
Thank you.
2025 CR 52, State versus Darrell Ray Tanner Jr.
That is Mr. White's case. I believe it's just a review, but Mr. White is in court in Montgomery County. The year as soon as. That's all.
All right, we'll put it on the second call. Have a seat, Mr. Tanner, until your lawyer arrives. 2024 CR 40, State versus Dylan A. Marsh. Mr. Clemens. This is retired, I think.
Be dismissed, Your Honor, and I believe that the state may be going to do that. He has completed the class that he's required.
Yes, Your Honor. I believe it's combined with everything and he's doing the rest.
So does he still have some things he's got to do? Is that right?
I
Or
think-
he's done everything he's supposed to do.
I think it's ready.
So he's retired to be dismissed, and the case will be dismissed. So he has court costs to pay.
That's printed off on Friday.
What?
That was printed off on Friday in our office.
$678.50. So the order of dismissal won't go down until he pays that.
Yes,
Right. So don't dismiss it until he pays that.
All right.
2025 CR 67, State versus Aaron Miller.
Well, this is Mr. Finley's case. I believe his dad was going to stand in for him today. He was asking to pass his motion and state is not going to disagree with that. I believe we settled this case. But I don't know what his dad.
So
I think he'd emailed Miss McKinney about resetting it, but let me call down.
Mr. Finley,
Yes.
he said that he had, court in
Yeah,
Clarksville,
in Clarksville, so.
and that, he needed another status date, requesting waiver of appearance for himself and his client. And I let him know that. And to discuss that with you, the motion needed to be made.
well,
Yeah, he needed to be in agreement, all that stuff.
the fact is that it was. Let's see.
I think he can be here after lunch, he said, Your Honor, if his dad was coming.
I have a problem with him coming in on Zoom if that's what he needs to do. I'm just trying to figure out what we're doing with his client. So the motions were set for today, but he's wanting to pass the motion.
And I'm fine with that, Your Honor. I think we'll.
Why don't we just pass it to that August the 10th day and save everybody the trouble? We'll pass, Mr. Miller, your case will be passed for the hearing on motions and final status day, which means y'all don't work something out on that day, then I'll set you a trial date. Once I set you a trial date, you'll be required to go to trial or plead to the indictment and go to sentencing. Okay, stay in touch with your lawyer. August the 10th.
You want me to ask a question?
Yes,
Me and my family drove down here, it took 20 hours to get here.
I'm sorry.
It's 20 hours for me to get here. I live in Minnesota. Just wondering if there's any way if it's just another hearing, what's if I could be heard on Zoom? Obviously for the trial, I would have to be here. It's another thing.
Well, let your lawyer deal with that. He can file the appropriate motion to allow it to be considered by the court. We don't normally, since you're here in person, allow an oral motion for you in the future to not appear, but I'll consider it if Mr. Finley files the appropriate motion. We'll look at maybe that's for just the status. It would not be possible for a trial.
You'll know before your next
Yeah.
court date.
Yeah, I appreciate it. Thank you.
All right. Twenty 2025 CR 68, State versus Robert Paul Norman. Clemens.
Yes, Your Honor. Your Honor, I've lost contact with Mr. Moore. If he's not here today, that I can tell.
Robert Paul Norman.
I think I have to tell the court that.
Well, since he's not here on the day for the status hearing, I'm gonna have to revoke his bond. If you found that there was some legitimate excuse for him not being here, such as hospitalization or some other issue, then you just get in touch with me and we can set it aside. But right now, I'm gonna issue, you know what his bond is?
I will. Thank you.
Looks like it's given a war bond.
Has an OR bond. I will revoke that OR bond, issue a capias for his arrest, $5,000 for the bond, cash or commercial only. And I may have said it capias for the defendant arrest. 2025 CR 34 State versus Wesley Joe Price. Again, Mr. Clemens.
Yes, Ron. Mr. Price, we have seven ready.
What?
Yes. Pass this up, please. Judge, Mr. Price is going to be, signing a guilty plea for this case, but it's going to be on a judicial diversion for 1 year. And the other case is going to be dismissed in 7.
All right, so the one he's actually entering the plea to is the
The forgery case. I believe.
forgery, all right. And the other one's dismissed outright.
Yes, Your Honor.
All right. Mr. Price, raise your right hand. Let's place you under oath.
You solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you.
State your full name for the record.
Wesley Joe Price.
Mr. Price, you're here today on 2 different indictments. It's been indicated you're going to be entering a plea to one, a plea of no contest, which means that you're not going to admit you did anything wrong, but you're not going to deny or contest the state's evidence when they tell me what their evidence will be at trial. And that evidence will be used by me to put you on probation for 1 year. I'll explain further what the significance of that is. But do you understand what you're charged with, and have you seen or been shown a copy of the charges, talking over with Mr. Clemens, you and he discussed the range of punishment you're facing, as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter this plea of no contest. You understand you can plead not guilty to all charges and have a speedy public trial by jury.
Yes, sir.
You understand if you went to trial, you would be presumed to be, you would have the right to have a lawyer and have one appointed if you cannot afford your own. We've done that with a public defender.
Yes, sir.
You understand that at trial, you would be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you, Mr. Clemens, could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir, I do.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is to approve what your lawyers worked out. You understand that? Now, you understand that under 4035-313, so-called judicial diversion, that means you're going to be on probation for a year. You're handing me this guilty plea or this no contest plea. I'm going to put it in your file, and for 1 year, you're going to be on probation. If you do everything you're supposed to do, stay out of trouble, and complete the terms of your probation, then at the end of that year, you can apply to have your record expunged. It won't happen automatically. You will have to apply to have it expunged. You understand that? But on the other hand, if you violate the terms of your probation, not only will you have to serve a year in prison, but you could, and it will become a permanent conviction. It could be brought back in front of the court to re-sentence you within the range of punishment for the offense that you're pleading to. You understand that?
Yes, sir, I do.
You understand everything I've explained to you?
Yes, sir, I
Do
do.
you want to go ahead and enter a plea of no contest according to this agreement?
Yes, sir, I do.
Is your decision to plead no contest today voluntary?
Yes, sir, it
Is
is.
anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty.
Yes, sir.
I want you to listen as the state tells me what their evidence will be if this case went to trial. You know?
The state would put on proof that on November 6th, 2024, Mr. Price forged a check with his wife or ex-wife's name on it, Denise Price, and tried to utter that check at F&M Bank in Stewart County, Your Honor. And instead of putting it in his account, they put it in her account, so then it violated order of protection, and that's where we are. Everything's been cleared up.
Are you satisfied with your attorney services?
Yes, sir.
Mr. Clemens has done a good job of representing you.
Yes, sir, yes.
Mr. Clemens, you don't have any reason you shouldn't enter this case.
No, Your Honor.
And Wesley J. Price, upon your plea of no contest in 2025 CR 34 to the count of forgery, I order that you be placed on probation under 4035-313 for a period of 1 year. You'll be on supervised probation. And that is the report. He needs to see the probation appointment. So.
Yes, sir.
We have Amber Hayes here. Hayes is on page 3. Ms. Hayes is represented by Crystal Wilkerson. We heard from Ms. Wilkerson today. So many of you heard from Ms. Wilkerson. Trying to locate your lawyer. I don't assume that you've heard from her, have you? To know where she is today.
Actually, is Kendall White here?
Yes.
I don't know if he's filed anything.
I'm sorry, what?
I think Mr. White was supposed to file something on her behalf. I'm not certain.
He's the one that's coming later.
Yes, sir.
Apparently we've got a lawyer who's going to be coming, but coming later. So just have a seat. We'll try to come back to you whenever he is here.
Let's wait.
Peter Falger tried. I just pronounce it, but I think it's Fabio Chudrid.
Yes, Your Honor.
It's as close as I can get.
Yes, Your Honor. Your Honor, this case has, I filed motions on this, one of the most pertinent, which being the request for bond. Your Honor, I have a special request on the case. The Tennessee Wildlife Resources Agency has produced a wonderful investigation of this case, full color photographs of it. If Your Honor would take this up after the break and if Your Honor would consider reviewing this at the break, this would tell you everything we need to know about the case, more or less. And I would request Your Honor consider doing that before we proceed any further on.
All right. State have any opposition to me reviewing this information? We'll put it on the second call.
Thank you, Judge. May I pass this up to the court? Yes.
Dean Roy. Mr. Loy, you have several motions that you have filed pro se, and I am going to have to recuse myself because you have previously sued me in federal court. And as a result of that, I think it was under the rules of procedure or under the rules of judicial conduct, I would not be able to hear any substantive matters in your case. But do you want a lawyer to represent you since you're in custody?
Mr. Clemens was representing me in General Sessions Court, but now I'm pro se because I moved to circuit court.
All right, Mr. Clemens, you have any problem with? I'm going to go ahead and appoint Mr. Clemens, but Mr. Clemens can explain more fully to you that I would be prohibited from hearing any substantive matters in your case because of the fact that you had sued me in federal court. So I'm going to appoint him to represent you, and then we'll see if you can have those motions reset in front of a different judge.
Thank you, Judge.
Your Honor, Mr. Lloyd has a civil case. All the judges in the judicial districts are confused. That would be the same for this criminal case.
That's what I was gonna thank you.
All 4 judges have recused themselves
I
from
think so.
Mr. Lloyd's cases. So then we would need to have Judge Lockhart Nash, the presiding judge, reach out to get a special judge.
Okay, I'll send her an email.
You have a lawyer. Let's see what Mr. Clemens can help you with, and then we'll get you a judge.
Thank you, Judge.
So the next non-inmate was going to be Dewey Preston Robinson. That's Mr. White's case as well. Is that correct? Mr. Robinson, you're represented by Kendall White. Mr. White has told us that he is happened to come from Clarksville after he completed something there, so we'll have to come back to you. Thank you. 2024 CR 46B, State versus William B. Singletary. Mr. Singletary, you're here to be arraigned on a violation of probation warrant. You have the right to an attorney if you wish to have a lawyer represent you. It's alleged that you were placed on probation for a period of 4 years that have been extended for 1 year on the 8th day of July 2024 for the offense of theft. It is alleged that you have violated the terms of your probation by using the illegal drug of fentanyl as evidenced by the results of a drug test conducted on February the 2nd, 2026 and confirmed positive by the lab for fentanyl. That is a violation of your probation, which could mean if we have a hearing and you're found guilty, then you could be revoked to serve the entirety of your 4-year sentence. So that's what your place was, show that he's been arraigned. We'll give you a copy of that. The question I had asked you is, do you want a lawyer to represent you? Pardon?
Yes, sir. Probably do.
Yes, you probably do. Do you want to hire one? Are you able to hire a lawyer of your own choosing?
No, not really.
Raise your right hand. Let's place you under oath.
You solemnly swear from the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God.
I'm going to have you fill out what's called an affidavit of income and expenses for me to determine. It's not an automatic thing that just, you want a lawyer and you want to have one appointed. The only people who can get an attorney appointed are people who are indigent. Inmates, for example, they have no means of hiring a lawyer, so we automatically appoint one of them. If you've made bond, then I have to have evidence before me to determine that you are eligible to have an attorney appointed because you are indigent and you don't have the ability. We'll come back to you after you fill that out. Thank you. 2025 CR 31B, State versus Benjamin Sogsog.
That's the companion case. Mr. Bagel to grab, Your Honor. Just call it when we call. Second call out.
Second call. 2026 CR 20, State versus Ashley Stanley. Mr. Clement, you have a motion to withdraw?
Motion to withdraw, Your Honor, the conflict with one of the other folks involved in the case. Ask, we're all considered urgent.
On your list. They'd be up here underneath all my stuff. All right, on your conflict, I'll allow your office to withdraw. We'll appoint Mr. Kendall White to represent this defendant, so.
I have a proposal to pass up.
All right, that's fine.
Thank
We will need to copy of the records from him. That's all for Mr. White to hear about. 2025 CR 53, State versus Nathaniel Ryan Taylor. Defendants of your case.
Yes, Your Honor. We have a settlement ready on this one, Your Honor. Let's pass it up, please. Mr. Taylor's going to be pleading guilty to DUI first offense, received the mandatory minimum penalties. He has already served the required jail time. Be placed on probation, required to pay the fine, driver's license revoked per year. I've also passed up a the notice of enhanced punishment. I provided him with a copy. We've reviewed that. He was waived the reading.
All right. Mr. Taylor, raise your right hand. Let's place you under oath.
Do you solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down now. State your full name for the record.
Nathaniel Ryan Taylor.
Step up there a little closer. You won't have to bend over. It'll just pick you up and see you just.
Nathaniel Ryan Taylor.
Mr. Taylor, you're here today charged with driving under the influence of first offense. Do you understand what you're charged with? And have you seen or been shown a copy of the charges? And you and Mr. Clemens talk about the range of punishment you're facing and any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest. Do you understand that means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence, and their evidence is what I'm going to use to find you guilty according to this agreement. You understand that?
Yes, sir.
Do you understand you have the right to plead not guilty and have a speedy and public trial by jury in this court? You understand that if you went to trial, you would have the right to have a lawyer and have one appointed, as we've done with the public defender. I need you to speak up just a little bit because we're recording everything. You don't have to bend over, but just talk a little louder.
Yes, sir.
So, do you understand that if you went to trial, you'd be presumed to be innocent until such time as ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted?
Yes, sir.
You understand that at trial, you and Mr. Clemens could confront and cross-examine all the witnesses the state called to testify, and you could bring in your own witnesses by use of a subpoena.
Sir.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Sir.
You understand if you went to trial, you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Sir.
You understand that by entering this plea of no contest, you're waiving your right to the trial and to the appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
You understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
As Mr. Clemens stated, I've been handed a document called the Notice of DUI Punishment that can set forth all of the enhancement provisions of the law. In other words, every conviction carries with it the next one being more severe.
Yes, sir.
Did you go over that, and do you understand all of those terms? Do you have any questions about it?
Yes, sir.
All right. Do you understand everything that I've explained so far?
Yes, sir.
You want to plead no contest according to this agreement and waive your right to a trial?
Yes.
You don't want a trial, you want
Yeah.
to take this plea, okay?
You know.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
You understand I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty. In other words, I have to have facts to support your finding you guilty. Since you're not admitting anything, somebody's got to tell me what you did for me to find you guilty. You understand that?
Yes.
All right, so just listen as the state steps up to the microphone or uses the microphone on the desk there to tell me what their evidence would be at trial.
Your Honor, if we had taken this to trial, the state would have put on proof that on March 28th of 2024, the defendant was observed traveling on Highway 20 here in Stewart County by then Deputy Park, the Sheriff's Office. He recognized the driver, Your Honor, and knew that he didn't have a valid driver's license, so he conducted a traffic stop. And he made contact with the defendant. The defendant said, I shouldn't be on the road. And the deputy noticed an odor of alcohol, performed field sobriety tests. The defendant performed poorly on those field sobriety tests, such that the deputy thought he was under the influence, arrested him for DUI, and the defendant admitted to having 3 assaults.
Right. I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial? You still wish to plead no contest? You still want to take this deal?
Yes.
Are you satisfied with Mr. Clemens' service?
Yes.
You think he's done a good job representing your company? All right. Mr. Clemens, you know of any reason you should not enter this plea?
No, Your Honor.
All right, then upon your plea of no contest, Mr. Taylor, I find you guilty, or that you be sentenced to 11 months and 29 days in county jail and will be suspended after you serve.
It's okay.
That will be suspended after you serve 48 hours. You're going to be on probation, but you're going to have 48 hours in jail, but you're getting credit for the time that you've already served, which is more than 48 hours. Your ordered to pay a $350 fine at court costs, and your loss of driver's license will be for 1 year. You must complete the DUI school with victim impact payment. All right, thank you. Mr. Clemens, when I was practicing, I had a case in another county in which my client was charged with DUI. And they had a videotape of him when we were watching it with the DA get ready for the trial. And they were trying to get him to perform his field sobriety test. He said, I can't do that, I'm drunk. Needless to say, we didn't have much of a defense after that. So.
Understood, Your Honor.
Right. 2023 CR 103 State versus Billy Russell Tomlinson. It's also your case, Mr. Clemens.
Yes, Your Honor. Mr. Tomlinson, come on up, please. He had been locked up in another county on some unrelated matters when this case got started. He and I think, are meeting in person for the first time today. He called me when he got out of jail in the other county. This has been set for status. I'd like to set this for another status.
Right, August the 10th.
August the 10th.
Right. State versus Crystal Romero Quintana. That was the expungement, correct?
Oh, yeah, we took care of that before. Your Honor.
Well, State versus Dylan Estes.
Your Honor, that's my case. Thought Miss Caroline Wright was gonna have some pre-trial motions set today, but she's gonna set them on the 22nd.
All right. We're going to set them on the 22nd.
Yes, Your Honor, that's the day before trial.
Yeah, it's a Houston County case, not a Stewart.
Gotcha. That's cool. All right. And we have one add-on case, which is State versus Barry D. Gray. More.
Judge, Mr. Gray had his two cases, one of the cases paid. He's got a motion in there.
Gray, raise your right hand.
You solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, self you got. I do. Thank you.
I'm going to have you've got a motion for me to waive your remaining fines of $1,500 roughly dollars. Before I can do that, I'm going to need to see what kind of economic situation you've got. So I'm going to have you fill out an affidavit of your income and expenses for me to see whether or not there's any basis for me to relieve you of that obligation. All right. You fill that out and I'll come back to you, okay?
Thanks.
See. Yeah.
Mr. Nixon is up there now.
Mr. Nixon is represented by Mr. Stanford. Have we heard from Mr. Stanford today?
No, Your Honor.
Possible not, you know, maybe
Mhm.
his assistant attached. Now, usually doing so. I said that if they'd have to take it up with you, so especially the morning of, she was here this morning, his assistant. Had her.
She's out.
Hmm.
She's out.
Is Mr. Stanford's assistant?
Yes.
Good. Let's have her come in. Looking for Dennis Stanford.
Yes, sir. He had car trouble and was not able to get here today. We were trying to find another attorney who's willing to argue his motion unless he can go by Zoom or WebEx. Or we can push it to another.
Or what?
Or we can push it to another day or next month. If that is okay.
Well, first of all, let me You're saying Mr. Stanford can't make it here at all today, correct?
Yes. Unless you have another availability during this week.
Well, we have a trial that was supposed to go tomorrow, but it has now been settled. I'm sorry, been continued. Is that the only thing that was set tomorrow, Joe?
I'm sorry, Paul Davidson?
The-
Yes, sir.
Tomorrow.
Sir, we have a
All
hearing.
Davidson case was set for tomorrow. It got continued. Is that the only thing that was set?
Yes, sir.
Who's arguing this motion with Mr.? This is, Mr. Nixon.
I know I've spoken with her, the state's in the objection to furlough on Mr. Nixon. So.
I can do, I'll probably get it for yours.
Okay.
I can do it, Your Honor.
Well, Mr. Nixon, your lawyers filed a motion asking for you to be furloughed to go have an evaluation done. And have you evaluated and treated you? I've dealt with you a long time. Do you have any problem with being furloughed to a treatment center?
Judge, well, I asked for that last time I was in here. I asked for it when I got sentenced last time.
State does not. That's all right. Mr. Nixon and I know each other well,
Very
so
well, thank you, Judge.
I will approve the motion for,
State does object.
oh, they do object. I'm sorry. I thought you said you don't
We
object.
object to any kind of furlough in this case, really.
All right, well, then we'll need to set it for a hearing. Can you do this tomorrow?
I can do it, Your Honor.
What about, Mr. Stanford? Do you know who
I
he's,
can make sure that he's available. sir.
pardon?
I can make sure that he's available.
Okay. Then let's, before we leave today, I'm gonna take a recess to review this, other information here that I've got to deal with. And we'll come back to Mr. Nixon's case. Is there anybody else who has a matter that we've not dealt with? We're waiting on a couple of lawyers.
Just Mr. Singletary.
Hmm.
Mr. Singletary, thank you. You don't say.
William Singletary. Singletary, I had you placed under oath, but this information that you've supplied about your total income, is that true and correct? You're on disability, is that correct? All right. I find Mr. Singletary to be indigent, therefore all points public. We already give you, I think I gave you your copy of that affidavit, so you might want to share that with your lawyer.
Your Honor, on behalf of Mr. Singletary, has already been given a copy.
It's an affidavit of violation probation. You want to have it set for next month then?
Yes, Your Honor, please.
What is the date in May?
5/11.
May the 11th. All right, I'm going to take a recess to review the information that the Clemens has provided, as well as some other information. We'll come back to you.
All rise.
All rise. Board is back in session. You see to come to order.
And I think we have, some matters that maybe we can address before we start any of the hearings. The first one would be on the, Mr. White, Kendall White, Darrell Ray Tanner Jr. on page 4.
Washington's hands.
Have a seat. All right, let's move. Robert Kaiser, Ms. York, are you ready on that?
Yes, Your Honor. Yes. Go ahead.
I had filed a motion to withdraw or in the alternative continue this case. Mr. Kaiser is adamant there is, missing body cam footage. So I was gonna request a continuance to investigate that. Aside from that, he just really hasn't been listening to my advice or really having much to do with anything that I have to say.
You have a motion to suppress down today, correct? And your motion to withdraw is based on the fact that there's supposedly missing, some missing body cam footage?
Yes, that's correct.
What evidence do you have to believe that there is actually any missing evidence?
I've talked to, Mr. Woodall. I personally don't have any reasonable belief there would be. But I followed it just out of abundance of caution.
Can I say something?
Yes, sir.
Mr. Chad Cox got it. And I've notified him ever since I've been in. He's talking about his office is getting renovated. He don't have time to find. Because he was my attorney. I had, in my discovery, there was one fiber out, whatever you plug into those to look at your discovery. He had one. She has 4. And the one she had, Mr. Cox didn't have, because I think it was extras to it. It was a lot more to it than what's been asked. So I asked her to get what she has sent off to the lab, to the TBI to make sure, because I know it's been tampered with. Because that ain't what I'm seeing. I know what he showed. But since he stepped down, now his office is in renovation. He didn't send it. And the things that I read is like he shouldn't even done nothing with it until 2 years or a few years after my case is closed. So why is now all of a sudden it's gone? And he keeps sending different stuff. My discovery pack was filed with Runyon. But since
So how many different lawyers have you had?
Runyon, he stepped down because he's a friend of the sheriff's, which had nothing to do with this case, but the courts allowed him to do that. She's a relative to the police that's on my case. So really, I can't be truthful to her.
On this case, Jay Muller, Stewart County Sheriff's Office?
No, on the ones that's also set for
We're
today.
not worried about
That's
that
the
one.
ones that's set for today.
The one that's set for today is the motion that the case that's set for Thursday, is it Thursday?
Yes, Your Honor, it's Thursday.
Set for Thursday for trial, and those charges are possession of a firearm by a felon, revoked license, first offense, the unlawful drug paraphernalia, and seatbelt violation. That's the only case that is set for Thursday.
But I was told I had cases set today, and it's not the one she filed. It was for a four-wheeler and a Class E felony, a class for evasion arrest. That was also set for today.
That's set for status apparently, but it's not
Right.
set for trial.
Yes, I can't be truthful to her when, it's just a conflict. I mean, I've asked her to file those motions. Every time I ask her to file something, she says she's got to ask the DA or go to the DA. The DA is not working with me. I'm working with her. So even her uncle told my wife that the DA is going to prosecute me. So how does her uncle know? Let's just get it talked about around the kitchen table. I cannot trust that. So I've spoken to 2 attorneys that I was going to hire, but I'm in jail, so I can't hire. But like again, she's handled a lot of stuff of mine. But when I ask her to file something, it's always, but the DA said this, the DA done that. What about the evidence that we supposed to be collecting? She hadn't investigated where I was pulled over at, why I was pulled over, the body. It's a lot to it. It's a lot to it. And I can't even address nothing with her because it's not confidential. It goes from her mouth to her uncle's mouth or to the DA's mouth, and I can't do that. That's why I don't talk to her. She told me the first time I talked to her, I know her dad. So I said, how? She won't tell me.
I have not disclosed any information regarding this case to anyone, so.
Well, I was made aware of the obligation or the argument that you had to make about her situation. I'm not so sure that my first inclination was that I was not going to grant her motion to withdraw and I wasn't going to continue your case because it's been pending since 2021.
Yes, sir.
And she is the 3rd or 4th lawyer that you've had appointed, and we keep appointing lawyers, and then there's a solution. Be quiet when I'm talking.
Yes, sir.
That there are several times that that's has to happen. My concern now, generally, despite what we had discussed in the chambers, is that Ms. York is being placed in a situation where she's likely to not have a good way out of it. If she continues in the case because I don't grant her motion to withdraw, then it seems to me that that will create an issue for post-conviction relief that otherwise would not be present if she is allowed to withdraw. And that resolves the issue about supposedly the lack of discovery, although I'm of the opinion that this is a pretty straightforward case. I mean, it's a case of driving on a revoked license and in possession of a handgun. So I don't know how the evidence could be that, but the state is objecting to a continuance and a motion to withdraw.
That's correct, Your Honor. State's, it's the state's opinion. This is Mr. Kaiser's another attempt, Mr. Kaiser, just to delay this case. Been going down the road. State's been ready since Mr. Runnion's had this case. The state's been ready since Mr. Cox had this case. The state's ready for trial Thursday. I understand your ruling.
Clemens, what conflict does your office have with this individual?
I don't recall the exact conflict. I think it might have been that there was PCR filed against our office. Mr. Kaiser.
That's been 25 years ago.
Your Honor, I'm happy to be stand in if you needed to appoint a counsel, and I could probably go forward with trial on Thursday as well if I get the discovery today.
And you're Mr. White?
Yes, Your Honor.
Well, I'm going to allow Ms. York to withdraw on her motion based on the fact that she has divulged that there is some relation between her, someone in her family distantly has some relation to another case that this defendant has. And I'm of the opinion that it's puts her in a position where the appearance of impropriety could attach. So we're going to protect Ms. York from having that issue raised by allowing her to withdraw, and I'll appoint Mr. Kendall White. Now, Mr. White, you can talk with General.
I'll be glad to talk.
with all about it and see if you can be ready for trial before I leave today. I just need to know if we're going through with the trial on Thursday. So,
Yes, Your Honor.
all right. Thank you, Ms. York.
Thank you, John.
Judge, I have a big in trial settings. I have an easy one. Dewey Robinson is on your docket. If we could set him for trial, I don't think the state and I will be able to make any kind of,
Who was it? I'm sorry.
sorry, Your Honor.
Who was that?
Dewey Robinson, Your Honor.
Clerk is throwing files out. Let's see. Hold on. Louis Preston Robinson on page 7 of the docket. Do we need to set a trial date?
Yes, Your Honor, we need a trial date.
We can set it behind Paul Davidson, like in August,
And that date is
the 8/11. We can do that in August.
August the 11th.
August the 11th, Your Honor.
Correct.
I'm available. That works for us.
Okay. There's one priority report.
It's not an urgent.
Now, with what my rule is under this scheduling order that we put down, that once it's set for trial, then it'll go to trial or he'll plead to the sentence, plead and go to sentence.
Yes, Your Honor.
All right, thank you.
Your Honor, I also have Miss Amber Hayes on the docket.
All right.
Your Honor, Miss Hayes, we're in an interesting situation here. It's taking me a little bit of work, but she has over 2,400 days of credit on this sentence. It's a 8-year at 85%, 8-year, 30%. You've served 85% of her sentence at this point, Your Honor. I know we are here on a pending violation. However, with that many credits, it'd be remiss of me to just say plead guilty and other than terminate because she's hit over 85% of her 8-year sentence, Your Honor.
Have you talked to the state about whether they would agree to that?
I talked to the state, and I don't know that they're in a position to do that because of Mrs. Hayes' record with this court, particularly.
That's correct.
You know, Your Honor.
Running Carlos, not back to court, and I believe she has new charges.
All right, so you don't have an agreement. So the question is whether or not you want a hearing or you want to just, if you don't want a hearing, you can plead guilty and go to a sentencing hearing, or you can have a hearing on whether she's violated her community corrections. That's up to you. But as far as me predicting what I'm going to do, I'm not, I don't give advisory opinions.
Your Honor, let me have a minute to confer with my client, and then we'll come back.
All right, then,
Yeah.
I think we can take up the state versus peer
Yes, Your Honor.
legality pride, legality pride.
Yes, Your Honor.
All right, there are several motions. The first motion is your motion to dismiss counts 1 through 8 based on the statute of limitation.
That's correct. That's the defense motions and in looking at the tolling statute and case law, the state is conceding the misdemeanors, Your Honor. They are time barred.
Misdemeanors must be, prosecution must be commenced within 1 year from the date of the.
There's no proof that he was actively avoiding.
So counts 1 through 8 are dismissed by agreement based on being barred by the statute of limitations. All right, and you have also motions.
Well, that would be misdemeanor, not count 1, Your Honor, because that's the email. Just the misdemeanor count. So that would be count 2.
So the counts 2 through 8 are what you're dismissing.
For Peter, it'll be count 3. 5. And 8. Because the co-defendants are charged together. Mr. Sogg saw every other.
All right, so counts 3,
5.
5, and 8.
Let me make sure that.
I'm looking at the indictment and those do appear to be the ones.
Okay.
And then you also have count 1 and count 10. And those are the two that Mr. Clemens is planning to argue about. Mr. Clemens, I will hear your argument. I think your motion is to dismiss count 10, but I think count 1 and count 10 both are covered by your first motion to dismiss count 1 through 8. And then count 10, you've also got a motion to dismiss for failure to state an offense.
Your Honor, I have, of course, the two motions. Count 10 is within the statute of limitations, being a higher class of felony, so it's not an argument as to statute of limitations. It's only
Failure to state an offense.
If I may, I'll launch into my arguments as to count 1 in the statute of limitations.
All right.
Your Honor, in this case, there's a superseding indictment which came out of on July the 7th of 2025. And it alleges in count 1, a Class E felony, criminally negligent homicide that supposedly occurred on July the 1st, 2023. Therefore, on its face, this indictment is beyond the statute of limitations. It's been 2 years. It's about 6 days late. The law would allow a superseding indictment to indict the offense after the statute of limitations if the offense had previously been indicted by a prior indictment. This would then only replace that. And so I looked in the file to see whether, in fact, a prior indictment within the statute of limitations had been issued, and found, to my surprise, the answer appears on the record, at least, to be no. Prior indictment was from the May term of the grand jury in 2025, and it has, amongst its charges, there is, under count 2, an indictment for criminal negligent homicide, which matches the language in the superseding indictment. However, when I go to the back of the indictment, I see that there is a list of counts, and next to each is written either true bill or no true bill. And count 2, which would have indicted my client criminally negligent homicide, is not listed on that indictment. This should be apparent from the file. And so for that reason, with nothing to show that my client was ever indicted for criminally negligent homicide under count 2, we cannot show from the record that there was any indictment for this offense prior to the superseding indictment, which, as we've noted already, was 6 days late. Now, on that basis, I would ask that the case be dismissed. Now, I will grant that in my informal discussions with the district attorney's office, they say that this was an oversight, a clerical error. Perhaps it was, but if it was an error, I don't know that it was made by a clerk. And even if it was, I think the error is a significant one. Something as significant as forgetting to write that a person was indicted for homicide is significant. It cannot be cured by the later indictment because it is beyond the statute of limitations. I do not know, even if this was some sort of error, whether Your Honor could or should allow the state to correct that error at this time. If they made a motion to correct a clerical error, I do not know exactly what proof could be presented to Your Honor as far as what testimony may or may not have been heard by the grand jury as to whether this indictment could have or should have been issued. But as the file stands right now, my client was never, according to this file and according to these indictments that I did provide with, indicted for this criminally negligent homicide until after the expiration of the statute of limitations. On that basis, I would ask Your Honor to dismiss.
General, you want to respond to that, and then we'll move to his next motion.
Your Honor, I did file a response, I believe. I hope that Your Honor's had a moment to read that. It is a clerical error, Your Honor. I can be sworn in and testify if I need to. And I have Ms. Lynn here. She prepares my indictments, and I approve them. General Kraus approves them. But if you look on the back of the first indictment for May, the issue is there are 2 count 1s. The first one, count 1, 3, 5, 7, and 8 are for Socksaw. And the next was supposed to be 2, 4, 6, and 9 for Peter. The only issue is there are 2 count 1s. When under Peter's charges, it should have said count 2 instead of count 1. So when we realized we were going to supersede that to do the Miss McDonald as a victim in July, all we did was shift the count 2 that was indicted up, count 1. We did not represent this charge. Count 2 was a true bill in May. Count 1 for Sogsog was the no true bill. It is simply a mistake on the back of the indictment. Instead of filing a motion to correct, we just shifted the count up in July. So Mr. Fagelgrad was indicted on count 2/count 1 in May, well within the term of statute of limitations. It's a simple clerical error, Your Honor.
You wish to be heard anymore?
Yes, Your Honor. Your Honor, the Assistant District Attorney has generously offered to be sworn in and to testify for the purpose of being able to say, well, the grand jury actually did vote to indict him for this particular charge. The problem with that I see, it would be that the district attorney is not allowed to be present at the grand jury when they are doing these things by my reading of the law. And it would seem that if we wanted to prove such a thing, we would need to call a witness that was actually there. For example, we could call some of the grand jurors, perhaps ask them, hey, did you guys vote to indict this man for criminally negligent homicide? And if we had perhaps the foreman of the jury say, well, yes, we did. And I say, then I would ask him, well, why doesn't it say so on the paperwork here? And if he said, well, I forgot to write it down. I forgot to write down count 2. I didn't notice that. We would still then have to decide whether this is the sort of error that can simply be overlooked. But without such proof, I don't think we're in a position to do that. And based on the record, I ask that Your Honor consider dismissing this case.
Well, this court finds somewhat differently in that when the review of the May 2025 indictment, the original one, not the superseding one, the back of the indictment has certain hand notations made. And clearly, the count 1 as to this defendant shows criminally negligent homicide as a true bill. The count 1 also is shown as to Benjamin Sogsog as not a true bill. The error was not in the handwritten portion of that by the grand jury, but rather in the counting of the indictment counts, because there are 2 count 1s, when obviously one applies to Mr. Sogsog, the other to Mr. Whatever, the defendant in this case. It is clear to this court that there is a typographical error made by the defendant, by the district attorney's office in noting the number of the counts themselves. The actual face of the indictment or presentment does show that count 1 applied only to Mr. Sogsog, and that count 2 was to the defendant in this case, and that was a criminally negligent homicide count. So therefore, the court finds that this was an error, a Scrivener's error, or an error in the preparation of the indictment as to the number of counts, but not the offense for which the defendant was indicted, and that has been corrected by the superseding indictment. The purpose of the indictment and presentment in any event is to notify the defendant of the crime that he is charged with. And the court is of the opinion that he was given plenty of notice, and that this is not a matter where the grand jury failed to indict him. In fact, it says just the opposite. They indicted him on criminal negligent homicide. It's just the number of the counts that was the error. And that was on the part of the district attorney and not the grand jury. And for that reason, this court is of the opinion that the motion to dismiss based upon that reason would be denied. We have another motion as to count 10, failure to state a cause of action, if I understand correctly.
Yes, Your Honor. Count 10 of the indictment charges the defendant with reckless aggravated assault. It states that he did unlawfully engage in reckless criminal conduct with a watercraft that resulted in the serious bodily injury of another person. To wit, and here's the portion where they would describe his reckless operation of the watercraft, says the defendant was the adult passenger of a personal watercraft that was being operated by a child under 12 years of age who was operating recklessly and thereby collided with another personal watercraft, causing serious bodily injury to Caleb McDonald. On the face of the indictment, then you can see that no reckless conduct is alleged against the defendant. It is said only that he was a passenger of a watercraft that was being operated recklessly by somebody else. Reckless conduct by somebody else cannot be attributed to the defendant unless the defendant does something reckless himself. It is only alleged that he was a passenger, and Tennessee law does not permit a passenger to be charged with reckless assault based on the operator of a vehicle's reckless conduct as alleged. And when the facts, as in the indictment here, affirmatively negate an essential element of the offense charged, that is, there is no reckless conduct alleged to have occurred by the defendant, it is subject to pretrial dismissal. We ask that Your Honor consider doing so.
Your Honor, the state also filed a response to this motion. The key words to pay attention to in count 10 are that the personal watercraft is being operated by a child under 12 years of age. Under the boating statutes, Your Honor, 69.9101 and 69.9505, that would put the adult passenger as criminally responsible for that minor child operator of watercraft. State argues that this is more of a factual issue, as the facts would show that the defendant was unable to take control of the vessel, which that's what the law requires when an adult is on the back of a PWC. And the facts would show that he was unable to do that, and that was the reckless conduct, Your Honor. So we charged it under criminal responsibility theory.
All right. Clement, do you have anything further?
Yes, Your Honor. Part of what's going on here is that for someone to be criminally responsible for the conduct of another, would have to have some sort of mens rea, something going on in their mind and something going on in their actions that links their criminal conduct and is the same as the reckless conduct. Even if we were to grant that he was in some way negligent, then it still would not rise to the level necessary to be able to indict him for a reckless crime, as the state has attempted to do here. For that reason, I ask that Your Honor consider dismissed.
The indictment in count 10 alleges that the defendant was an adult passenger on a personal watercraft being operated by a child under 10 years of age. Tennessee Code annotated 69.9505 states the following: it is unlawful for any person under 12 years of age to operate a personal watercraft upon the waters of the state of Tennessee unless such person is under the direct supervision of an adult. Direct supervision means being in such a proximity with an operator as to be able to take immediate control of the vessel. In reviewing the Tennessee Wildlife Resource Agency's investigation, their findings are that the defendant was not in a position where he could take control of the vehicle, and therefore he was in violation of that particular provision of the law. The count that we were talking about alleges that he engaged in reckless criminal conduct by being a passenger and allowing the child of under 12 to operate the motor vehicle or the watercraft rather, that collided with another. And I think that in the reading of the statute that the child was prohibited from driving it unless this individual was able to control it, and reading the facts as set forth in that investigation, this court is of the opinion that it does become a factual issue for the jury to determine whether or not he did it, whether his violation of that statute considered to be or would be considered to be such reckless criminal conduct as to render him liable for it. I think that is a factual nice. And the defense is free to renew its motion to dismiss following the trial of this case, so that my opinion is that the indictment is sufficient to put the defendant on notice of the charge and the basis for the charge. And it's a matter of factual basis whether the jury would find that there is a proof beyond a reasonable doubt that he is engaged in reckless criminal conduct. And I'm allowing the defense to renew this motion following the trial of this case to determine whether or not there is a basis for a dismissal. That is my ruling. Your last one is a motion for bonds. Are you ready on that?
Yes, Your Honor.
And you have both a motion to set bond and a motion for individualized bond determination, which is basically an application of the bonding rules. Pretty much what I do in every case anyway. So
Yes, Your Honor.
any reason for a different hearing in that?
No, Your Honor. I would proceed as a normal bond hearing.
And I'm ready to hear it.
Your Honor, I would like to first offer as an exhibit the report of the Tennessee Wildlife Resources Agency, which I previously provided.
You've given me a copy of it, and I have it here, so I'm going to provide that to the clerk.
And I would like to merely draw the court's attention to the facts as presented in there and the conclusions of law enforcement at the end, which conclude that as far as any recommended charges, that they recommend that perhaps Mr. Probate might be charged as an accessory to the misdemeanor violations of allowing that and more. No such things as homicides or assaults is recommended by that report, nor I would say is strongly supported by the facts. The facts as set forth in the report are straightforward. Mr. Probate was one of two passengers riding along behind the operator of the personal watercraft, who was following along behind somebody else's personal watercraft. The one in front turned in front of the one being operated behind it, and the one behind it continued on straight, and they collided. If this were a civil trial, we would be throwing around terms like contributory negligence. We might look into whether the operator of the other watercraft had any responsibility for these actions. Of course, my client would be a potential plaintiff in such a suit, even being injured in the incident as well. But for our purposes, it's much more limited. He is being charged with criminally negligent homicide and reckless assault based on the theory of criminal responsibility for somebody else's reckless conduct. He is also co-defendant along with the child's father, who we would say is the one more responsible for making sure that the child is old enough to operate a watercraft and is wise enough to operate it in a non-reckless manner. I would also like to present as an exhibit, if I may, this is, let me pass this up, please, Your Honor. I've taken the liberty of getting a diversion eligibility certificate, and I would like to pass that forward for the purpose of demonstrating that my client has no prior significant criminal record and is facing, at this point, a Class E felony, and I believe a Class D felony at most, for which he would be eligible for a post-trial diversion even if we were to go to trial and lose. There is no intentional bad conduct alleged against my client. It is not clear from the report that he even knew the age of the person who was operating the watercraft, and I would think that may become significant as to what level of proof he had to show that he can say that he did anything wrong. His bond is I think $50,000 right now, and Your Honor has already, with the agreement of the state, seen fit to dismiss most of the 10 charges against or rather the 5 charges against the others were related to the other person. In consideration of all this, Your Honor, we ask that the bond be lowered and that he be allowed to make a more reasonable bond. We would suggest at most $10,000 for this case and allow him to be out of jail on a reasonable bond while awaiting this trial, which will take a few months to get put together.
All right. Anything other than argument you wish, and these two exhibits that you wish to offer?
No, Your Honor.
State have any proof you wish to offer or argument you wish to make?
No, Your Honor, we defer to the court on here issue of bond. Mr. Bagel's does not have a criminal history. It did take a while to locate him within the country. That's the issue. We just want to make sure that if he's given a bond and he's let out, that there is some sort of way to make sure that he's going to be available for trial. We had to have our investigator, Tom Peppers, located and we extradited. So that's.
I ask a question, is your client here under a valid visa?
Your Honor, I'm glad you asked that, and I meant to bring that up. My client is, yes, he is from Micronesia, which I didn't know much about till I got this case, have to be honest.
Nothing about it.
It's a U.S. territory by, similar to, but not exactly like Puerto Rico. He is a U.S. citizen. He's not an
It doesn't require, excuse me for interrupting, I apologize. It doesn't require him to have a passport to go to his home to come back to the United States, to the mainland United States.
I think my understanding is it does require a passport, but it's not like he's from a different country. We've got some sort of treaty along with him, which essentially treats him as a citizen. He's free to live and work in this country right now, which he's been doing. And I would certainly accept any reasonable orders to say not go back to Micronesia, which he has no plans to do so at this time. And I would emphasize that it would be very foolish of him, and he would have every incentive not to screw any of these things up because of the nature of the charges against him are what they are, because of his opportunity to, even in the worst case scenario, be even eligible for diversion. It would not have any particular consequence for him as far as immigration, as we could tell, because as I said, he's not really an immigrant in any sense. And so for all those reasons, Your Honor, I would ask that a reasonable bond be set.
This is a tragic case, and I've made the counsel for both parties aware of the fact that the person who was killed or deceased as a result of this, Mr. Roy Heron, was someone that I had had met a couple of times. He is not a friend in any stretch of the imagination, but I had met him on a couple of different occasions when he was running for public office, among other things. But I don't think there's any basis for me to recuse myself, and I've made the lawyer aware and there's no objection. But it is a situation where it's a tragic circumstance. Mr. Heron and a young lady were on a watercraft, and as they entered into the neck of an outlet, so to speak, at the lake, Kentucky Lake, this other craft operated by a boy who was 11 years old at the time, and also had the defendant on the very back end and another child in between, came behind the Heron's watercraft, and then there was a collision that occurred, and Mr. Heron sustained what ultimately came out to be fatal injuries. So it's a tragic circumstance. As Mr. Clemens has pointed out, and there are a lot of car wrecks that occur from negligence that are not criminal in nature. In this particular case, the state has alleged that there was a violation of the criminal statute, and as a result, it is a criminal case. The defendant, by proof before the court, has no prior criminal record, and as a result of the dismissal of about 5 of the charges against him, it leaves him with 2 still significant cases against him. And for that reason, I'm of the opinion that the motion to reduce his bond should be considered by the court. The court is required to look at the factors set forth in 4011-118. Those include the defendant's length of residence in the community. It's not shown that he was a resident of this community. In fact, he's a resident of Micronesia who's here in the United States under based on my questions, he's here with either a proper visa or has a legitimate legal residence here in the United States, mainland United States, whatever. I don't have any evidence about his employment status, family ties or relationships. I don't have any evidence about his character or mental condition. I do have on number 5 in this factor, he has no prior criminal record. The nature of the offense, apparent probability of conviction and likely sentence. Obviously, you know prior criminal record, the defense, even if convicted, would be asking for a court to consider the judicial diversion statute as part of the sentence. The nature of the offense, again, this is an offense which clearly is somewhat creative is not the right word, but it is unusual. And there's no strong likelihood that the defendant would be convicted. I think it's going to be a question for the jury, as I pointed out earlier. So that factor would be a factor in favor of the defendant. I don't have anyone who is a member of the community vouching for him. He has no ties to the community that I can be aware of. Number 9 is any other factors indicating his likelihood to appear. I think that he's lawfully present in the United States, lawfully present here. He has no prior criminal record. This is a tragic case, but his responsibility is different in that he's not the one who actually committed the crime. He is the one who had responsibility for a child who committed the crime. And I'm thinking about that 11-year-old boy now who has to worry about living the rest of his life being responsible for the death of another individual. That's a tough situation. In any event, I'm of the opinion that the bond should be set at $15,000. The only conditions I would place would be that Mr. Faljakrad should surrender his passport to the clerk of this court if he intends to stay within, and if he's going to exit the United States, he'll have to file a motion asking for leave of court to leave the United States mainland. And he is to stay in touch with his attorney and make sure Mr. Clemens has his current mailing address and contact information at all times. That's a condition of his bond. Right. Then we are, that concludes everything. Are we setting him for status? We haven't set him for trial, have we?
Status.
Your Honor, I would ask that we go ahead and set it for trial. I'll admit that.
Fine with me.
Been 2 years. I want to get this thing moving.
Well, we didn't get your client in custody until January.
Do what?
We didn't get Mr. Fables here until January of this year. So
How long will it take you to try this case, to get ready for trial? Can you be ready in August?
I can be, but it's gonna take, with all the evidence, it would probably take 4 days, Your Honor. The discovery is massive. I just want to ask on the record, is the PD's office not entertaining any offers? We haven't made it.
Oh, I'd be happy to talk, settle it between now and trial. I just don't want to play.
Well, that's the problem with setting it on the trial date. When our rule that I'm operating under is we don't set it for trial unless it's going to trial or pleading to the indictment or going to sentencing. So let's give you a status date in August 10th. And if you are unable to resolve, that'll be the final status day. And if it's not resolved, we'll find you a trial date as soon as possible.
Yes, Your Honor.
You stood up to say something.
I was going to remind the court that, Mr. Co-defendant sought.
They are about to out August 10th status. Okay, yes. On socks off, we'll look for 8/10. If the court's okay with that.
Fine. Mr. White, you have something else?
Your Honor, we have Ms. Hayes. We will be entering a true plea to that violation, Your Honor, and then we would ask for a sentencing hearing, just to basically establish her jail credits.
Well, we're at 5 till 12. If we want to take that up, we'll take it up at 1 o'clock after we've had our lunch.
That's fine, Your Honor. I don't have anywhere to be. I also have Daryl Tanner, but I need to talk to the district attorney about that one. So yeah, Your Honor, we'll just take up Ms. Hayes after lunch, and then
let me go back. I think we had second call for an attorney.
Just before we adjourn for lunch, are we doing Mr. Nixon tomorrow for sure?
Are we doing one?
Mr. Nixon tomorrow for sure?
No, I was waiting to see if we heard anything back from Mr. Stanton.
Yes, Mr. Stemmer wanted to find out if you're on Wednesday instead.
Well, right now, we have a trial on it, so.
And I don't mind doing it, but I mean, is it gonna take a long time?
No, it's just the argument.
I don't mind doing it Wednesday if you're on it.
I don't want to do it in the middle of a jury trial. So. What about moving it to Houston County? Any reason we can't move the motion to the Houston County docket call, which would be Monday, April
Wednesday, yeah.
I'm sorry, April 21st, Tuesday. No, that's not right.
Wednesday,
April 22nd.
He is available.
we just didn't make sure transport order comes.
All right, we need to get a transport order from Mr. We'll have the hearing on Wednesday on that motion. So that concludes then, Mr. Nixon. Any other inmates that we have other than Ms. Hayes? Right, there was a second call on pardon me. Someone that was a question that came in. Barry Gray. What? Ray, is all this information set forth in this affidavit true and correct?
Yes.
What basis are you asking for the court to remit your funds and costs in this case?
Pay for my monthly expenses, I have to fund the lot. Basically, I had used a previous small inheritance to pay off what I had paid off already and to establish a place of residence last summer. I just haven't been able to make other payments since.
Well, you've made a lot of progress. I'm going to remit $1,000 of your remaining amount. That'll leave you owing $565. Okay. Well, that'll give you some consideration. With your income, I realize it's not a lot, but you have the ability to make small payments. So. But by reducing it by $1,000, that'll give you a chance to try to pay it off. Okay?
Thank you very much.
All right. Thank you. Anybody have anything before we break for lunch?
Your Honor, I have an easy one with Mr. Tanner. I was able to confer with the state, subject to the court's approval. I believe that matter will be dismissed. Mr. Tanner was put on 6 months of probation. Was put on probation in November, or supervised visitation probation. He completed it. There was a question about February. He got confused and went on unsupervised because he paid all his fees. I think the Houston County Probation Service got a little confused. However, he has successfully completed it with drug tests and everything else, I believe.
We've had no negative.
All right, Mr. Tanner's case is dismissed pursuant to that agreement.
Thank you, Your Honor.
Thank you. With who? Good. Oh. Yeah, we can do that right quick, so. Melissa Holloway's case. Come up, Mr. Perry. Your motion, do you wish to testify about any part or put on any proof regarding your motion for exoneration?
I'm sorry, sir, I couldn't hear you.
Sorry, this is your motion. Do you want to testify about the circumstances? I've looked at your motion. Do you have anything you want to offer in addition to your written motion?
I told you earlier last time that basically I've tried everything. I called the sheriff's department, San Bernardino. They wouldn't do anything. Called the courthouse. She had court over there that day. They wouldn't hold her either.
I'm gonna, because of the fact that I need to look at the statute on this, I'll take it under advisement. I'll give you a ruling in hopefully a very short time. So. All right, thank you.
Thank you, Your Honor.
All right, we're standing in recess for lunch until 1 o'clock.
All rise. Yeah. have an order.
Judge, on the Kaiser matter, we're passing that motion, and we're just gonna be prepared for trial for Thursday. And then we will notify the court by Wednesday if there's any conflicts at noon.
All right, then if you'll let us know by Wednesday if you're gonna go forward with the trial on Thursday, then I'll agree to continue it if a good cause exists to have to reset it, but.
Yes, Your Honor, just for the record, I just want to appreciate Mr. White for taking on this case at such short notice. And I've given him a copy of the body cam footage. If he sees any issues where he needs to file a motion, I figure we can just do an agreed order and set it for a motion date in August and a trial date in August.
All right.
I don't think this case will settle.
Do you have one question about jury instructions, Your Honor? Have you guys sent those out yet, or
What about?
proposed jury instructions?
Right.
I just want to review those if the court has them, or is
Well, we
prepared.
haven't drafted them yet. We usually draft them the morning of the trial.
Oh, you do the morning of trial? Okay.
Once we know for sure it's going and, because of the 5 counties, we have to do jury instructions until we start the trial.
That's fine, Your Honor. I just, Thank you, Your Honor. I said earlier, Ms. Hayes is going to plead true to her violation, and then, she would need to be sentenced. We have on record that she has, give or take a day, 2,397 days of credit, combining her community corrections time, her in-service time, her furlough time, or in the pen time. We would argue that the sentence is terminated. Or pleaded, she served her time. At this time, Your Honor, we would just say plead true and terminate, and let Ms. Hayes move on to her next charge tomorrow.
The next charge tomorrow.
That's correct, Your Honor. The state, if she owes time, the state would prefer that be served.
It's a 6-year sentence imposed in 2018. And based on what I'm hearing, it does appear to me that this time she served on her plea to the court would be inclined to just hold that she has completed a sentence.
Was there an 8-year sentence in 2019?
It was an 8-year sentence in 2019 that runs concurrent with the original 3-year sentence and then 2 1129s from, but all of them are running concurrent. So that's where she gets a compilation of her credits, Your Honor. It's because they're running concurrent, she would be given those credits on both charges.
All right, so I'm looking at one of these and there's obviously more than one. All right, Ms. Hayes, if you'll raise your right hand, let's place you on the road.
You solemnly swear or affirm the testimony you're about to provide with the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. State your full name. Step in front of the microphone. Step your full.
Hayes.
All right. Ms. Hayes, if you'll just stand there while I go through this explanation of your right. You understand that you have a right to plead not guilty to this charge of violation of community corrections and have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation.
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
You understand if you went to that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you waive your right to that hearing and that appeal. And I will then make the pronouncement of sentence that I think is appropriate.
Yes, sir.
You understand everything I've explained to you?
Yes.
You want to plead guilty according to what has been represented to me.
Yes, sir.
And upon your plea of guilty, I find you guilty of violation of the community corrections. But upon your service of your time today, the court is of the opinion that you have completed your service according to release eligibility. Therefore, you are terminated from probation. Thank you.
Thank you, Your Honor.
All right. So right now, that concludes today's docket, correct?
Thank you, Your Honor. That concludes my business. May I be excused?
We are waiting on Wednesday to hear from.
Waiting Tuesday for me.
Tomorrow, we have to hear from you by noon about the trial on Wednesday. Wednesday, we have to hear from Mr. White.
Trial Thursday, Your Honor. Is there a chance that if you do go to trial, we'll go over on the third? Okay, I just figured I'd ask. Thank you, Your Honor.
Then we stand.